Hey everyone, thank you for joining today. We are so thrilled to have you with us. We have a lot of ground to cover today. So, as you're coming in, if you'd like, you can put in what city you're coming in from. This is a California legal webinar, but I'm curious to see, are you Northern California, Southern California? Go ahead and put that in the chat. Let us know what city you're coming in from. We'd love to just be able to tailor this a little better, especially in the follow-up. If you are in a specific area with maybe some local ordinances, we can get back to you with more information about that. I see Margaret from San Jose. Hi, Margaret. Welcome, welcome. So just a little bit of background here. My name's Alexandra. I'm the Director of Marketing and Education here at the American Apartment Owners Association. And today we're going to go over, firstly, the balcony inspection laws that are relatively, I guess they're not new, but they've just gone into effect recently. And then we'll have Stephen Williams, attorney, come in and talk about some of the other laws that are in effect. To start and to kick this off, we have with us Greg Carlos. He is the VP of Operations at Dr. Balcony. As the name says, Dr. Balcony does balcony inspections, but they also do a lot more. They are actual engineers and they have a lot of experience, not just in this space, but in other engineering aspects as well. So we're going to start with Greg here to give us the first part of our legal update today.
Thank you, Alexandra, and thank you for having us today. So yes, my name is Greg. I'm here on behalf of Dr. Balcony. We're going to be speaking about the California Balcony Inspection Ordinances, SB 721, SB 326, and then also introducing a new bill, the AB 2801. I'm going to keep it short. I know we're a little short on time, so my apologies if I'm zooming through this, but I will be in the comments after if anyone has any questions. So California balcony inspections, why they're important, why they started. So in 2015, a tragedy occurred in Berkeley where six young adults were killed and seven were injured due to a balcony collapse. After further investigation, um, the reason of the balcony collapse was actually determined to be due to dry rot. This was really surprising because the building was only 9 years old at the time. And because of this incident, the SB 721 and the SB 326 ordinances were introduced, requiring regular mandatory inspections on any exterior elevated elements such as walkways, balconies, stairs, decks. Anything that's above 6 feet off the ground has a walking surface meant to be walked on and relies partially or wholly on wood for structural support and stability. Needs to have a regular inspection. So the SB 721 and the SB 326, what they are, like I said, they're the balcony inspection ordinances. How they differ are that both of them apply to any property with three or more units. The SB 721 is for apartments, and the SB 326 is for condominiums and HOAs. The deadline for the SB 326 just passed December 31st, 2024, and the deadline for the SB 721 is coming up uh, at the end of this year. Additionally, they differ in the sample size, where the SB 721, you have to inspect a minimum of 15% of each type of element, whereas for the SB 326, you have to inspect typically 100% of elements. The ordinance says that you have to have a 95% confidence rate. They have the SB 721 has to be inspected every 6 years. SB 326 has to be inspected every 9 years. And on the bottom, you can see who's eligible to do each type of inspection. Structural engineers and architects are eligible to do the SB 326 inspections. For the SB 721, structural engineers, architects, general contractors. There's a couple more people that can do these actual inspections. So a lot of people say, hey, well, my balcony looks fine. It's been there for 30, 40 years. There's no reason to need this inspection, right? It's not going to collapse. So I just wanted to include an example here where this balcony was really shocking because from the exterior, there was no dry rot. There was no There was no staining. There was nothing that indicated possible damage or collapse, on the in the balcony. However, after we opened it up, there was quite a bit of rotting, and that was really, really concerning because, um, like I said, nothing indicated that from the exterior, right? So you can see here, majority of the balcony is going to be rotted. So through our inspection and with our permits, right? We're always going to try to save as much of the balcony as possible, make this a smaller project for the clients if possible, right? We didn't have to tear down the entire balcony and replace it with an entire new one. As you can see there, there's some different type of repair methods such as joist sistering and other things that we did, to try to preserve what we can. But yeah, this balcony's ready to go, ready to give another 20, 30 years of life. So a new development that just occurred in regards to these balcony inspections um, is that there was actually just another balcony collapse in Los Angeles 2 weeks ago. So as you can see here, that balcony would have completely collapsed, and it would have ended up being a lot worse if that other balcony was not directly underneath it to kind of catch it and add a little support. Um, but yeah, this is in Silver Lake, happened a couple of weeks ago. So, it's yeah, tragic that something like this happens, but it does happen, and that's why these ordinances are so, so important. So once again, this was on February 15th. Four people and a dog were on a balcony in Silver Lake when it collapsed. Thankfully, no one there were no fatal injuries. However, someone did break their arm. We do believe that if the balcony directly under it was not there to catch this balcony, it would have ended up much, much worse. So the only positive that we can take from something like this is that due to this, a lot of local jurisdictions have started reaching out again, reaching out to us and started actually developing a plan on how they're going to track these inspection ordinances and how they're going to enforce them. So it seems to be that these ordinances are now being taken a lot more seriously, right? Since this happened. So there's definitely been a huge uptick from cities, from insurance companies reaching out, a lot of different things. So that's the only positive that we can take from this. So a lot of people ask what happens if I do not comply. So the ordinance does say fees of $100 to $500 per day for people that do not comply with these ordinances. You obviously have increased liability if you did not have your inspection as required by law, and someone were to get injured or hurt. You may have problems with selling your property. So since the SB 326 ordinance did recently pass, a lot of people are trying to sell their condominiums, and they'll call us and say, hey, I need an inspection as soon as possible because I'm not able to sell my property without having this inspection done. So, we'll go out there, do that inspection as quickly as possible and help the people sell that property. But um, the ordinance does say that at the time of sale, you do have to present any reports. Um, Additionally, we have spoken to multiple insurance companies recently that are looking into this. There is a possibility of being dropped by an insurance company if you don't have these these inspections done, right? Once again, they're mandatory inspections, so a lot of insurance companies are using this and saying, "Hey, if you're not complying with the law and making sure that everything is as safe as possible, we're not going to insure you." You can also be red flagged by your city, and the worst part is, guys, everyone's going to be forced to do these inspections down the line anyway. So you might as well do them now. Anyone that did the SB 326 inspections in November and December of last year knows how hectic that deadline was. A lot of people were trying to get in right before the deadline and they couldn't. Um, um, it's a lot more expensive. Construction's going to be a lot more expensive down the line. Cities are going to um, be really busy, especially with the wildfires that just occurred, right? There's going to be an increase in demand in permits and in construction. So we definitely recommend trying your best to get ahead of that rush. So really quickly, guys, once again, I'm here on behalf of Dr. Balcony. We are the leaders in this industry. We have done over 4,000 inspections to date. This is more than any other company in this industry. We have an app that's developed and designed to make your life easier as a landlord or a property manager. And Dr. Balcony focuses solely on the inspections. We don't do the inspections and the permits. So we don't do any sort of construction. So you have no conflict of interest. You can rest easy. You can, be assured that we're going to give you the most accurate results and the best price as well. We will price match any other company and beat them by 20%. So if you are looking for your inspection, definitely reach out to Dr. Balcony. And then really quickly, guys, I also wanted to introduce this new bill. I don't know if Stephen will be speaking about this today, but it's something that we're also working on currently. So the AB 2801 requires move in and move out photos, as well as photos before and after repairs of any units, anyone that's renting, right? The bill is designed to help tenants keep their deposits, requiring photo documentation of units before and after moving out, along with photos before and after any necessary repairs. Starting April 1st, landlords must take photographs of the unit after the tenant moves out, but before repairs or cleanings, and photographs once again after the repairs or cleanings are completed. So Dr. Balcony is currently working on a free software. We already have the software that we were using for our inspections. So we figured, hey, might as well help our friends in the, and the property management industry to help comply with this ordinance, right? So we're developing an app, guys. It's a software where you're just going to be able to store your photos, share them with the tenants. They're going to be able to upload them really easily for you guys to see. So we're trying to make your life easier, and hopefully we can work together on this as well soon. And that's going to be it, Alexandra, if you wanted to pull up those poll questions.
Yes, thank you so much. So we do have two poll questions up here. Would you like more information regarding that free software that Greg was just talking about? And also, if you want 20% off your balcony inspection, as Greg mentioned, the price may vary, but ultimately they do beat any competitor's price and by 20%, which is amazing. But just if you reach out to them, they also have the 20% balcony inspection. If you say yes to these questions, they will go ahead and follow up with you after this call. And then we're going to have actually attorney Stephen Williams come on and talk about some other laws that are going on in California. AB 2801 is definitely one of them. So we'll go into a little bit more detail on that in just a moment. If you do have questions concerning the balcony laws, I will be forwarding those to Greg and his team so they can get back to you with a detailed response just in the interest of time. And then we'll have some Q&A at the end for Stephen Williams as well, if you all want to stay a little later. So I'm going to go ahead and stop your share here, Greg. Thank you so much for the information. We really appreciate you coming on, and we'll be sure to share all of that with you so you can follow up with everyone on the balcony. Okay, I'm going to go ahead and end this poll here real quick. And Steve, I would love to have you start and share your screen. We are so excited to have you. It's been a while, Steve, I think, since you've been on last, and we certainly have seen a ton of new developments in law in California, especially in 2025. So I thought we should bring you back. Steve has been representing rental property owners throughout the Bay Area since 1999, which is just a wealth of knowledge and a ton of experience working with rental property owners. He's familiar with the California laws, but also specifically Bay Area laws as well. So he's going to be going over of all the new laws really that are affecting landlords. And thank you, Steve, so much for coming on. I won't delay this too much longer. I appreciate you coming to update our members.
Yeah, thanks. Thanks so much. So yeah, we do have a lot to talk about. And first, Greg, thank you for that. You did hit some important points. You mentioned that Berkeley balcony collapse. And since then, there's been some other collapses, like in San Francisco, there've been a few that have resulted in significant injuries and even deaths. So yeah, definitely take advantage, everyone, of that inspection. Make sure your balconies are up to snuff. And you brought up another important point. I actually just yesterday was in a talk on this, and we were discussing this exact issue. And you mentioned insurance can drop you. Well, even if they don't drop you, what if there's an injury and you have not complied with the laws? That may give insurance carriers some wiggle room to deny coverage. So again, all around, just make sure your balconies are safe, comply with the laws, and your balconies and your tenants. Make sure everyone is safe. You did hit on a security deposit topic, so you saved me a little bit of time here. That is on my list here. I'm going to get started uh, with some laws, some things for everyone to be aware of. This is not a comprehensive list. This isn't all the new laws, but these are some ones that I felt would be important to talk about that are of interest. And this is the outline here, but what about 10 things here? I want to first talk briefly about some of the actions in response to the LA fires, of course, the security deposit, some tenant credit reporting requirements, domestic violence also. There's been some changes there. And a significant one here is the response time in eviction lawsuits. So whether you have a non-payment of rent or some other type of eviction, you have some new time requirements for tenant responses. This one junk fee ban, this is just going to talk briefly about some fees that are no longer permitted for landlords to pass through or to charge tenants. Also, the Tenant Protection Act. I'm going to talk a little bit about that as well and some changes there. And Costa-Hawkins. If you're not aware what Costa-Hawkins is, I'll give a little summary of that as well and how it survived the November election and a proposition there survived. So also get into briefly some local things as well that happened in Northern California that may have some bearing as well throughout the state. So with that, let me go ahead and get started. Okay, first, the fire protections for tenants. Just a few. Now, these may vary in county to county and city to city, but just in general, I want to talk a little bit about what Governor Newsom did. He declared a proclamation of emergency in LA County. So in the counties up there or down there, there's what happens is when a government, whether it's local or state, so it could be county, city, or the state, Governor Newsom, issues a proclamation of emergency, whether that's in response to a fire, an earthquake. We've had weather-related proclamations of emergency. Of course, COVID, that's the big one. What happens when that is invoked, it automatically triggers a state law penal code anti-price gouging law. Okay. Generally, when the proclamation is made, the anti-price gouging laws are triggered for 30 days. Those can be extended, and they have been extended here. Okay, so the initial proclamation was back in early January. 30 days have passed, but Governor Newsom has extended the protections. And what the anti-price gouging, how it affects landlords, is that it basically says you cannot raise the rent more than 10%, okay, on a tenant during this time of emergency. And it goes even further that if you have a unit that becomes vacant and you go to rent it to someone new, you can't say, well, look at all these tenants are now displaced and there's much more demand. I'm going to charge 25% above the last rent I was charging. It also prohibits that. It says you can't charge more than 10%. So there's some limitations here that are intended to protect victims who are the subject of that declaration of emergency. So keep that in mind. This is going to continue at least for the next, week and a half or so through March 8th. I expect there will probably be some extensions of that. If I had to guess, whether by Governor Newsom or locally, there may be some local extensions beyond that. But as of now, at least through March 10th, no rent increases above 10%. Similarly, there is also a protection in place that protects tenants in LA County who are housing victims of the fire. So if someone was displaced by a fire and a tenant, for instance, lets a friend or a family member who's been displaced by the fire move in, the landlord cannot evict that tenant as a breach of the lease. Let's say there's a no subletting provision or no more than two occupants in a unit, and this allowing a family or allowing someone to move in who's been displaced by the fire, maybe that violates that lease provision. Well, Governor Newsom passed this law that says, no, you cannot evict for that lease violation at this time. Okay, so really, it has a good intent here, and landlords, you definitely don't want to push buttons and try to displace someone who's trying to help someone who's been, victimized by the fire. So again, that is lasting at least through March 8th. I am aware that the county is trying to pass some laws as well to extend these sorts of protections much longer. So stay tuned for that. But I just wanted to briefly touch on some of the state law protections that are running at least through March 8th. All right. So with that, now Greg touched on this a little bit earlier. There are some new laws relating to security deposits. And, when I started doing this back in 1999, the security deposit law was, maybe a couple paragraphs or a page. Now, if you look at the security deposit laws, it is basically a chapter in a book. I mean, they just keep adding on and on. There's all sorts of protections and requirements that landlords now must follow. And this is just an additional one. And basically what it says is, look, and by the way, largely, I would expect that a vast majority of landlords were already doing at least the photos at the inception of the tenancy. That's just a good practice. So this now just codifies it. What it requires is that effective April 1st, 2025, this year, at the beginning of the tenancy, the landlord must take photos to document the condition of the unit. Again, this has been a good practice anyways, and you share those photos with the tenant. This has just been a good practice for years anyways, to document the condition. Okay. Now, beginning July 1st, when a tenant vacates, you then need to take photos after the unit has been returned. So now you'll have the photos to document the condition of the unit at the beginning, and you'll have it at the end. Again, this is just intended to, keep the landlord honest, to show, and the tenant as well. The tenants can equally say, well, no, the unit wasn't in this condition when I moved in. Well, yes, here's the photos. And then here's the photos on the move out. Here you can see the differences between the move in and move out. Again, it's always been a good practice to take photos and document thoroughly the condition of the unit at the move in. Now it is required on move out as well. So just make sure you comply with that. Again, just another addition to the ever-growing security deposit laws. And if you don't do this, you could be dinged in such that you may not be able to withhold for damage from the deposit. And if this is done in bad faith, if you have violated the security deposit laws in bad faith in any way, not just regarding photos, but if you're not returning security deposit and you're doing so in bad faith, you could get hit with a penalty and have to pay more than security deposit as a penalty for violating the security deposit laws. Okay. So I'm going to be moving pretty quickly here. That was about it I wanted to touch on there. Let's talk about some of the new credit reporting requirements. Okay. Effective April 1st. So let me just a little bit of backdrop here. Throughout the years, landlords have been reporting tenants' bad payment habits to credit reporting agencies. All right. So tenant doesn't pay rent. Maybe there's a non-payment of a rent notice. Maybe there's an eviction, whatever it may be. That bad history may be reported by a landlord to a credit reporting agency, okay, historically. Well, this sort of levels the playing field that, well, a tenant may say, well, hey, if I'm subject to potentially bad reporting, I'd like to have good reporting as well. So what this law does is it allows for a tenant to say, yes, I would like for you, landlord, to report my good tenant rent paying history, right? This is beginning April 1st. The landlord must offer the tenant in writing this option. The tenant doesn't have to avail him or herself of this right, but they have the option. They can say, yes, I would like you to do so. And then the landlord has to make a reporting of good rent payment history. The landlord can charge actual costs that the landlord incurs to make this reporting up to no more than $10. So it must be the actual cost not to exceed $10. Okay. So this is likely going to just be incorporated into rental agreements now and going forward. That's where you'll make your disclosure. You just put it right in the rental agreement. If you have a tenant in place now, let's say you have a tenant in place and it's not in the rental agreement because this law wasn't in effect at the time, you can then notify notify the tenant in writing by April 1st of this right for existing tenants. Going forward, include it in your rental agreement. All right, this right to positive reporting of rent payments. There are some exceptions, and it's a pretty large exception. Okay, buildings containing 15 or fewer units are exempt unless the owner has more than one building and the owner is a real estate investment trust or a corporation or a LLC where one of the members is a corporation. So it's a pretty big exception. You can be an LLC with John Doe, Jane Doe as members, and you would be exempt, if you have 15 or fewer units, all right, in that building. So generally speaking, there's a pretty broad exemption for buildings containing 15 or fewer units unless the owner owns more than one and is essentially a corporation. Okay. Okay, domestic violence. So, if you look at the history, the case law history on domestic violence, there's been some lawsuits throughout the years where victims of domestic violence sue landlords for not promptly responding to a victim's request for certain concessions, or a lock change, for instance. This is the law. So what the law says, effective this year immediately, a tenant can request a lock change when the tenant or a member of the household has been a victim of abuse or violence. Okay. So if the tenant or the member of the household notifies the landlord that they are a victim of abuse and requests a lock change, the landlord must do so within 24 hours at the landlord's own expense. Okay. If the landlord does not do so, then the tenant can change the locks. And the landlord must then reimburse the tenant for that lock change within 3 weeks. The tenant must notify the landlord of the lock change within 24 hours and provide the landlord with the keys. The tenant, if the landlord has a key and the tenant changes the locks, the landlord is entitled to that key again, but must actually incur this cost. So this is a new law, and it makes sense that a victim of domestic violence should be entitled to some safety or protection. Like I said, there is some case law or some history where there was one particular tenant in the Bay Area who requested a lock change. and this was years ago, and the landlord was not quick to respond, and the abuser entered and actually ended up killing the victim. So as you can imagine, there was some significant liability to the landlord in that circumstance. So don't ignore claims of abuse and requests for concessions from a victim. And here now it's codified in the law. You have 24 hours to actually change the locks when requested to do so. Also, this law imposes a prohibition on taking a negative action to an applicant. So if a tenant comes and they have been the victim of domestic violence, and there has been some proof comes to light of this, a landlord cannot refuse the tenant applicant on that basis. So you can't take adverse action when you become aware of a victim's uh, suffering from domestic violence in the past. That cannot be a factor in your determination for whether or not to accept that applicant. Okay. All right. So this one's the big one here in the eviction world. A change substantively or procedurally to the response time in an eviction. So historically, after you serve an eviction notice, whether that's non-payment of rent or some other 60-day notice, for instance, that expires, you file your eviction lawsuit, you serve the summons and complaint in that lawsuit on the tenant. The tenant then has 5 days to respond. Historically, it's been 5 days. Then it changed to court days not long ago, so 5 court days. It is now, effective this year, 10 court days. So really you're looking here at 2 weeks when you count weekends. Maybe there's a holiday in there as well. It could be 14, 15 days, right? The tenant now has 10 court days to file a response to that lawsuit. Okay, so this just added about another week onto the time for a tenant to respond. And believe me, tenants take every bit that time to respond. They get more than they get plenty of help with tenant advocacy groups who help them with the paperwork, and they calculate the response date, and they darn well wait to the very last minute. They buy time, not uncommon. So this is going to add more time to your eviction process. All right. So expect that the tenants will avail themselves of that extra time. This law also changed time frames for certain types of responses that are filed to an eviction lawsuit. So typically, in response, you get an answer to the lawsuit. When you get your answer, you can then file a request to set the case for trial, and then the case is generally set for trial within about 3 weeks. Well, there can be some generally what I call delay tactics on the tenant side, but not always. Non-answer responses, and those are demurrers or motions to strike. Those can be filed in response to a eviction lawsuit. And what that does is it challenges the face of the complaint. It sets a hearing in court on that motion or that demur, and then the court has to look at the complaint and decide whether or not the complaint is sufficient to state a cause of action for eviction. If it is, then the motion is denied and the demur is overruled and the case proceeds. If it isn't, then the case is either thrown out or the landlord can file an amended complaint. But what the court did here is it said, well, now if the demur or a motion to strike is filed, it has to be heard or set for hearing within 7 days. This is actually good for landlords. It has been several weeks. It has not been uncommon for these to be set a month out after they're filed. This now streamlines it. So if they bring this delay tactic and request a hearing on a motion to strike or a demur, well, now it's got to be heard within 7 days. Okay. This may be subject to the court's limitations or availability, but this is a good thing for landlords because it streamlines the process to these, what I call often delay motions. So at least one good thing may have come out of AB 2347. So again, 10 days response time to the complaint, 10 court days, and the demur or motion to strike has to be set within 7 days, not a month out. Okay. All right, the junk fee ban. Junk fees are generally just fees that landlords sometimes will try to impose on tenants. Well, effective this year, a landlord can no longer charge a tenant a fee for serving, posting, or delivering any type of eviction notice. So let's say you serve your 3-day notice to pay rent or quit. Maybe you pay a process server to serve it. Maybe you serve it yourself, whatever. And maybe your rental agreement has a $25 charge for that. Tenant responds, pays the rent, so they're still in good standing. And then you try to impose that $25 fee. Cannot do that anymore. No more fees for serving notices on tenants, okay? Same thing, maybe you had a fee for tenant for payment of so you have a charge, additional fee for a late rent payment or a security deposit. You have a fee that you charge. Again, that fee for payment by check, that is a payment. Let's not mistake this for a late rent payment fee. This is just a fee for, like, if a tenant wants to pay by check, and for instance, you want that or prefer that the tenant pay electronically or through some EFT measure. So you try to impose a fee for the tenant's method of payment. That fee will not be valid anymore. Cannot charge that fee to the tenant. Okay, so these are just a couple of fees that have been banned or eliminated under Senate Bill 611. Okay, there's another thing I want to talk about here, which is, I put this under the junk fee ban. This is your application screening fee. You can generally charge an applicant a screening fee, which I believe it is now up to, what is that amount? It's about 50. I had it written down here. I don't see it anymore, but it's about $55 roughly that you can charge as a screening fee. Well, this new law is basically, while it has not eliminated that right, it has imposed requirements if you are going to charge a fee, which, as I'll mention, I'll show in a minute why this is probably now eliminating screening fees or making it less attractive for landlords. Basically, if you're going to charge that fee, this is, again, the tenant applicant submits their application and you charge them a fee to review and consider that application. If you're going to charge that fee, the landlord must, one, consider applications in the order received and accept the first applicant who meets criteria. Well, maybe that's not your standard process. Maybe what you do is you get applications in over a weekend and then you sift through them over the weekend. Maybe you get 10 applications and then you go through them and you select, the most suitable one. Well, if that is your process, you can no longer utilize that process. You must, one, if you're going to charge the screening fee, you must, one, consider them in the order they're received, first come, first serve, and two, accept the first one who meets your criteria. Okay, so let's say you've got a 600 credit score, and the tenant meets that, and then maybe 2 times months rental income, rent as income. Maybe those are your standard fees, that their income is at least 2 times the monthly rent. Then you get the first applicants who satisfy that, you have to accept. Or you have to return the entire fee to any applicant who is not selected. Okay, so if you've accepted, if you've received 10 applicants, you've charged 10 applicants, you accept one of them, you've got to resend or return all of the 9 other screening fees and do so within 7 days. So they're imposing these requirements if you're going to charge a screening fee. Okay. And there's another requirement. you must provide the tenant with a copy of their consumer credit report within 7 days. So every applicant and that you've received and every fee you've charged, you've got to provide that tenant with a copy of their consumer credit report. Okay, so they're making it not very attractive to charge screening fees. Okay, so that's why I mentioned here the effect of this law may be to eliminate this fee. Okay, just don't charge the tenant screening fee. If you don't charge the fee, you're not subject to these restrictions. You can continue with your standard, application process. Now, again, it's important to remember that any process that you utilize to consider applicants has to be non-discriminatory. So long as you have a non-discriminatory practice of screening or vetting your applicants, you can continue to do that and not be bound by these new requirements if you simply don't charge a fee. Okay, so keep in mind, if you want to continue to charge this screening fee, then you've got to comply with the laws regarding tenant applicants. Otherwise, with these new strict laws regarding them, otherwise, just don't charge the screening fee. Okay. The Tenant Protection Act. I want to talk about this. This was a pretty significant change to the Tenant Protection Act. Just as a little bit of background, the Tenant Protection Act is now statewide rent and eviction control. Okay, so all jurisdictions now within California, whether you're in a local strict rent control jurisdiction like maybe Los Angeles or Berkeley or San Francisco, if you're outside of those traditional local rent control jurisdictions, well, you now have the Tenant Protection Act, statewide rent and eviction control. That was, and basically it applies to all multi-unit properties, subject to some exceptions, and to many single-family homes, but there is a pretty significant exemption for single-family homes under the Tenant Protection Act. But generally, if you're subject to the Tenant Protection Act, it was revised and amended to significantly expand the owner move-in eviction requirements. So just in short, an owner can do an owner move-in under the Tenant Protection Act, displace a tenant, evict a tenant in order to make the home your home, your residence. Well, the law was revised to now say, okay, you can, but you have to live there for a year. It used to be there was no time requirement. You could just move in. Now you have to be there within a year. And you must move in within 90 days. That was not there before. So the owner move-in requirements have been expanded to require you to actually live there for a year and to move in within 90 days. Also, before you could evict a tenant in order to do a substantial remodel. Well, now you can do so, but you have to give the tenant the right to move back. And before doing so, you have to get all the permits in hand to do the work that you're intending to do before you serve your temporary eviction notice. And you have all sorts of other disclosures within that notice that you have to include. So the important thing here is the tenant has the right to move back, and you've got to go through a bunch of steps before you evict the tenant in order to substantially remodel that unit. Okay, so tenant has move back rights. It's a temporary eviction now, and any failure to strictly comply with the eviction requirements. So just as a little bit of backup here, I said you've got eviction and rent control now with it throughout the entire state of California. Under eviction control, what that requires is that you have basically just cause or good cause in order to evict. And the law, the Tenant Protection Act, outlines a number of good causes that you can use to evict. Cannot evict unless you have good cause. Okay, if your unit is subject to the Tenant Protection Act, and if you do evict and do not strictly comply with the Tenant Protection Act and all the notice requirements, then the notice is void, and that is a defense to the eviction, to an eviction. So if you evict on a void notice, that is a defense. And here's the significant one that does require your attention here, is that the Tenant Protection Act did not have a lot of teeth until this recent change. It didn't have a lot of teeth because there was no real penalty. There was not a significant penalty. There is now. So damages for violating. The tenant gets their actual damages. So whatever their out-of-pocket actual damages are. Let's say you serve an eviction notice that doesn't comply with the Tenant Protection Act and the tenant vacates. They have been arguably wrongfully evicted, and they're able to assert and potentially recover their actual damages, whatever they can prove. Maybe their moving costs, maybe increased rents, whatever they're paying as higher rents as actual damages. They can seek and potentially recover those. And now they can recover their reasonable attorney's fees and costs. So if they have to file a lawsuit and they prevail in that lawsuit, they will be able to ask the court for reimbursement of the reasonable attorney's fees that were expended in that litigation. And that's big because attorney's fees oftentimes drive these lawsuits, and they are significant. Not uncommon. I've seen verdicts for $200,000-$300,000 for wrongful eviction, and attorney's fees $1 million. Okay, so they oftentimes dwarf the actual recovery. So again, this is a significant change that was imposed to the Tenant Protection Act that gives it some teeth. Now you get these tenants' lawyers who are more than willing to take up the cause to sue a landlord on behalf of a tenant. I see it all the time up in local rent and eviction control jurisdictions. Well, now it may expand to Tenant Protection Act violations. Okay. And then here's another big one. 3 times damages, a penalty. So whatever the tenant's damages are, let's say they're able to prove that they had to pay $10,000 in moving costs, and there's a rent differential of $20,000. That's $30,000, right? Well, now if they prove that, they may get 3 times that if they can show that the landlord acted in willful disregard or was oppressive or acted fraudulently or maliciously with their conduct. If they can show that, then they get 3 times the damages. Again, this sort of mirrors what you see in local rent control jurisdictions, where you get that, what I call trebling or tripling penalty damages. So this is new in California, new to the Tenant Protection Act. And again, this is statewide. This isn't your typical Los Angeles or Berkeley or San Francisco or Oakland. This is the entire state. Okay, so I really wanted to emphasize that here today. Be aware, this is a new law. It actually went into effect of April of last year, but I felt it was worth talking about today because of its significance. Okay, I want to talk about this one as well. This was something that survived the ballot in November, and it's significant because Costa-Hawkins is the statewide law that basically shelters landlords in traditional rent control jurisdictions like San Francisco, all the very strict rent control and eviction control jurisdictions. They cannot touch units that are protected under Costa-Hawkins. It eats them up. They pass laws constantly trying to pick at Costa-Hawkins. So what Costa-Hawkins does is it basically prohibits vacancy control, meaning when a unit becomes vacant, the landlord has the right to set the next rent at market rate. Okay, the unit's vacant. Maybe you've had a tenant for 30 years that was paying 1/5 of market rent. That tenant moves out, you clean it up, you go to market, you can charge market rate. Okay. If the local rent control jurisdictions had their way, they would say, no way, you can't do that. The rent, that unit should be subject to rent control, even when it's vacant. Costa-Hawkins comes and says, nope, nope, nope. You local jurisdictions cannot do that. So that's why this was a very big win. is it protects vacancy control. It also protects single-family homes from rent control and condos from rent control. There are some exceptions, but in general, you have a single-family home in Berkeley, in Los Angeles, in Oakland, and that tenant is moves in, and their year lease is up, the rent's gone up 10%. You can raise the rent 10%. It's a single family home, as long as it's exempt under Costa-Hawkins. Costa-Hawkins provides these protections, and that's why I'm emphasizing why this was such a big victory. This was the third ballot measure to either eliminate or attempt to significantly reduce the effect of Costa-Hawkins, the third one in the last, 5-6 years. This was Proposition 33. It failed, and it was surprising to me. It failed pretty resoundingly. It was I think it was like 60-something% said no. No, we're not going to eliminate Costa-Hawkins. So it was a big victory for property owners, and a significant one. So just keep that in mind, and want to underscore the importance or significance of Costa-Hawkins, because it does provide significant protections for property owners. So again, going through 2025, Costa-Hawkins is still in effect, and in general, single-family homes and condos are exempt from rent control, not eviction control, but rent control. And also, you don't have any vacancy control anywhere in California. Okay, again, there's a few exceptions, but in general. Okay, I want to talk about a few local victories that may have some statewide impact as well. This was in San Francisco. San Francisco had a warning notice requirement. Okay, what it said is that in San Francisco, before you could evict for your traditional lease violation or non-payment of rent violation, you had to first give a 10-day warning notice. So you're basically giving the tenant a bite at the apple here that says, hey, you didn't pay your rent. Here's your 10-day notice. Pay your rent. Or, hey, you are violating your lease by doing X, whatever it may be. Here's your 10-day warning notice. Then you sit and you count the clock or the calendar, wait the 10 days, the 10 days up, the tenant still hasn't paid, or the tenant is still violating the lease. All right, well, then you can serve your 3-day notice to pay rent or quit, or you can serve your 3-day notice to perform or quit for the lease violation. So it's giving another bite at the apple. All right, then you have to wait for that time to run. The tenant has another opportunity. So that law imposed that 10-day requirement. Well, the court in San Francisco said, nope, that violates state law, which says you only have to give a 3-day notice in these circumstances. Okay. And the Court of Appeal in the appellate court in San Francisco agreed, resulted in a published decision. Now that published decision is limited technically to San Francisco, but it's persuasive. It's not binding in other counties or jurisdictions, but it is persuasive and could be argued against other local jurisdictions that have similar warning notice requirements. Now, interestingly, under the Tenant Protection Act, which we just talked about, there does happen to be a warning notice requirement before evicting for a lease breach. Okay, so there is a pre-notice or pre-warning notice requirement there. That is still in effect. That's a state law thing, so that was not impacted. This just speaks to local jurisdictions that try to pass additional notice or warning requirements for certain types of evictions. Okay, so in San Francisco, it's been eliminated, and that's final and binding. Outside of San Francisco, it's persuasive. You could argue that. Now, I wouldn't necessarily recommend that you run out and not comply with a local requirement that has a warning notice, but it does give you ammunition. If you miss a step, you could potentially make this argument, and it may have some weight in other jurisdictions. Okay, here's another one. So when you have a non-payment of rent notice, very typical for a landlord in your 3-day notice, you're required to state, to who the tenant must pay the rent, where, and how, and and include that in your 3-day notice to pay rent or quit. All right, most people know that. Okay, and not uncommon for property management companies. Let's just say ABC LLC. ABC LLC generates that notice and says, okay, you can pay your rent to ABC LLC, pay it between the hours of 9 to 5, Monday through Friday, at this address. Very common. Well, some jurisdictions said, nope, can't do that. This is Alameda County in particular. I'm going to point to them. They said, nope, you have to you have to state in your notice an actual person, a natural person. I mean, it doesn't make sense. We've been doing this for years. ABC LLC is the payee. That's who the tenant pays the rent to. That's who's on the lease. Well, Alameda County, some judges over there said, nope, you got to state a person. Didn't make sense. All right. So someone fortunately took it up. The Superior Court ruled adversely to landlords. Someone took it up, and the appellate court in Alameda County rendered a decision that is published. Said no, no, no. ABC LLC is perfectly suitable. That's perfectly fine. Which has been the practice for decades. They just, put it there in writing in Alameda County, saying judges in Alameda County can't do that. ABC LLC is fine. All right. Doesn't have to be John Doe at ABC LLC. You don't have to state that person's name. And the reason is because under the law, an LLC or a corporation legally is and I do my air quotes here, person under the law. Okay. So ABC LLC is perfectly fine as a payee in a non-payment of rent notice. Again, binding in Alameda County, persuasive elsewhere, not binding outside. But I'm not aware of too many other jurisdictions that have sort of gone rogue, so to speak, and ruled that way. But just know that that has been an issue, and it's been resolved at least in Alameda County, and there's a decision that supports that you don't have to necessarily state a person. So again, this was a victory for landlords, and I like to point these out at these sort of talks here because most of the laws that are passed are pro-tenant. You don't get pro-landlord laws. You just don't. So our pros come in defeats. So when we defeat, like we defeated the Costa-Hawkins proposition, that's a win. That's a victory for landlords. We, have eliminated this county from ruling adversely against landlords who, do what they've been doing for years in their non-payment rent notices. So I like to point these things out. Another victory to point out, and this one's still working its way through the courts, but I want to just point out some local jurisdictions impose or pass laws and purport to impose taxes on owners who have vacant units, again, to encourage housing. That's their rationale for this. So they tax you if you don't, either occupy your property as a home or rent it, like what they want you to do. Well, there was a tax in San Francisco called the San Francisco's empty homes tax, and it taxed property owners for vacant units, and the San Francisco Superior Court said, no, 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 that's illegal. Cannot do that. Can't force a landlord to be in the rental business, which is essentially what this is doing. So it struck that down in San Francisco. Now, I am aware that other jurisdictions have similar type taxes, and they may need to be challenged there. There's no appellate decision on this yet. The city in San Francisco has appealed it, but I do just want everyone to be aware that this, again, it's a victory, that at least one judge has agreed that this law is just not valid. But I wanted to point it out, so stay tuned. We'll see. Maybe we'll have an update next year when we're doing this talk as to sort of how this has made its way through the courts. But again, I just like to point out certain local victories or victories in general that we can cite to, in favor of landlords. All right. So with that, I think that is the last one. I went pretty quickly. Wanted to get in here under the hour or within the hour. So I went through it pretty quickly. But again, there's other laws that have been passed this year. This isn't comprehensive. Like one area, ADUs. There have been quite a few laws at the state level that are really encouraging property owners to legalize ADUs. So there's several laws out there that favor that, and they trump local laws. So they basically encourage the local laws to adopt them. Again, didn't have a lot of time to talk about other things, but there are other laws. But I just want to point out some of these important ones, the ones that I felt that were important.
Yes, you did a great job as far as timing went. And I think we covered at least the ones that would affect the most people here on the call today. I did want to relaunch the poll question. If any of you arrived late, we did have Dr. Balcony talk about the balcony inspection laws. So I'm going to go ahead and relaunch that one more time. If you didn't answer it the first time, please go ahead and answer the questions that you see on the screen. If you would like assistance with getting a balcony inspection to comply with California's balcony law, and also California's AB 2801 move in, move out inspection photos, which is now required for the security deposits. And that whole law that was passed as well that Steve also touched on. I'll leave that up for a little bit. We have a ton of questions. So please listen up. If you would like your question answered by Steve, please put it in the Q&A box, not the chat. I will not be looking at the chat. Chat is going crazy, guys. We have like 600 people on this webinar, so it's a bit much. So I'm just going to go through the Q&A. Steve, do you have a hard stop at any point here?
I don't.
Okay. Okay. Well, I'm going to try to take up as much as I can as far as questions go so we can get a ton of these answered. So question here. Can a landlord charge for his time? I think this might be due to the rental applications that we were talking about.
No.
Okay,
The,
great
the, the
answer.
rental application is a screen. You're only allowed the screening fee, and that is, here I have it right here, $59.67. That's 2025. That's your application fee. That's all you can charge. But again, you're subject to those requirements. So I'm saying, you know what? Don't charge it. Unless you want to subject yourself to those requirements.
Yes, that's good advice. Amanda, is a landlord allowed to increase the security deposit each year on the same tenant? And furthermore, the deposit is much higher than the rental cost. Is that legal?
So that would be a per jurisdiction question. So in general, you may be able to impose with a 30-day notice to change terms of tenancy, to increase the deposit to match the rent. It cannot exceed the monthly rent. Okay, so it's got to be what the monthly rent is. You can't go above it. So yeah, if you're raising the rent 3 or 4%, you might be able to get a deposit that to match that increase. But if you're in like again, San Francisco, I keep citing those three others as well, can't do it. Can't change the terms. So check your jurisdiction before you do so, and probably not worth it in general for the few extra dollars, but just check your jurisdiction.
All right. Sam asking, if someone owns two single family homes, will AB 2747 be applicable?
So let me go back to 2747. Which one is? I believe that is the new. No, let me go back to my slides here. Wait, why don't I put them back up? I'll leave the slides up so I can refer to them. Hold on one. I think I know which slide they're referring to.
Sure. Yeah, the rent reporting law.
Yeah, that's what I figured. Let me go back to it.
Yeah. So they're asking if two single family homes basically counts as two buildings.
Which is interesting. I mean, I believe it wouldn't, right? If they're single family, it's not a building, but who knows?
This one, right?
Yes, exactly.
Okay. So if you own, okay, so the exceptions are buildings with 15 or fewer units, okay? So if you are let's say you have two single family homes and you are a corporation, then this would apply. But if you own two single family homes and you're John Doe, Jane Doe, or John Doe, your trust, or ABC LLC, and John Doe is you're the member, then yeah, you're exempt. But if you're a corporation, then no, you're not. Or you're a real estate investment trust. I rarely come across real estate investment trust, but if you're a corporation, then you're not exempt from this.
Okay. Chris asking about the domestic abuse. We have some questions on that. Does the abuse need to be documented? Would you need a police report required to validate that kind of request?
Yeah, there is a documentation requirement, but it's generally you have to have like a court order or even something from a reliable third party source like a police report or something like that. Well, a police report may not be a reliable third party source, but here's my general rule of thumb here. Don't be hard and fast on this. I mean, be safe, okay? If there's any reason to believe the person is subject to domestic violence, just change the locks. I mean, even if the tenant orally tells you, if you believe it's true, better safe than sorry. You don't want that situation that happened in Berkeley where the abuser comes in and you end up with someone seriously injured or who dies. Be proactive and responsive in the situation. Don't say, well, nope, I need to see something more official. Just don't do it.
Yeah, and I'll also say too, nowadays, a lot of our members are using smart access control, easy to just recode and issue a new code rather than having to make a completely new key. That's also really safe. So you can change that at any point in time, pretty much with a click of a button. So I would recommend looking into that if you haven't already to look at smart access control. We have some solutions on our site for that if you go to the solutions tab on aaoa.com. Also, must the landlord change the locks without, oh, that's the same question. How often can they request the lock change? That was a question that came up a couple times. I think you sort of answered it in that, yes, documentation, but also, kind of see what is the request for, and is it reasonable, and maybe just do it if it is something that could endanger the person potentially.
That's a good question. So, and I just was talking about this yesterday at another talk, and so it's not uncommon for victims to reacquaintance themselves with the abuser. It happens. And so maybe they give that person a key and everything's fine
Mhm.
for years or maybe weeks. We don't know. Again, I would be safe, rather recommend you be safe than sorry. And maybe in that situation, it goes back into the same pattern of abuse and they ask for another lock change. I would just give it. Don't be a stickler for that. Yeah.
Yeah. Yeah.
And smart locks makes that easier. Nick saying here, what actions does the landlord have to take if the person being accused of the violence is also listed on the lease agreement?
So that's a good question. And so here's what the law says is that you may have to allow the victim to move out without penalty. Okay. So if let's say the victim says, you know what, I'm the victim of this abuse, I'm out of here. You have to allow that person to leave. Okay.
Mm.
So you can't say, well, but you still have 3 months on your lease. I believe that there's like a 14-day allowance that you can allow for that the tenant would be responsible for up to 14 days. You know what? Just let the person out. Just let them go, and they wouldn't be responsible for the rent going forward. Okay. So
Okay.
yeah, they do have some rights to just simply terminate the lease.
Gotcha. Okay. Moving on to a kind of different topic here as far as rent increases go. So, have Teresa here in Southern California in the city of Los Angeles, currently under the state of emergency. They've had a vacancy since December and they're looking to put it on the market in April. They've made some cosmetic upgrades. The old rent was $1,300 a month. The new rent they want to charge is $2,900. That's quite a big jump. Are they limited on how much they can charge due to the previous rent back in December?
So that strict read. So okay, well, let me back up. First of all, the price gouging laws might not be in effect when you go to market in a month.
Hmm.
I suspect they might be, but they might not be, okay? In which case you'll be all right. If you are going to market and the price gouging laws are still in effect, this is a criminal law, okay? So um, you could be subject to criminal, you know, sanctions. Better safe than sorry, but there are some exceptions depending on the circumstances. So what you want to do is look at the anti-price gouging laws, and if you have done things to fix the unit up that may entitle you to a greater rent to accommodate those things, okay? But you want to be careful. I would one, check the law at the time. Two, under these circumstances, I would say that it would be a slim chance that this would go on catch the radar of anyone, um, given the circumstances. Displacement prior to, and then so far after you've done significant work, upgraded the property, it may not get on anyone's radar, but um, there are certain areas where prosecutors are looking to make a name and point people out. I'm seeing it now where there's egregious price gouging going on. There are people being made examples of, generally large companies or corporations that are charging more rents that, outwardly, and increasing rents. This particular scenario isn't the type that would necessarily catch someone's radar, but it could. And generally, probably you'd want to either hold off or check to see where we are with the anti-price gouging laws at the time, or take a look closely as to what you might be able to avail yourself of for the upgrades that you've done.
Yes, you never know who's watching, no matter how big your operation is.
That's right.
Yep. David asking here about the court hearings being set in the 7 court days. What if the court doesn't actually set that hearing? Then what would be the landlord's rights in that case?
Yeah, you are okay. So the courts are obligated to set eviction lawsuits for trial within 21 days of request to set it. We've seen for years they don't always do so. Okay. You're kind of at their mercy. I suspect the same thing will be the case here, that the courts will probably try, but it may be probably more like 10 days. Um, Unfortunately, you're at the court's mercy. There is a procedure where you could go into court on what's called ex parte notice, means you just show up within 24 hours of letting the other side know that you intend to do so. You show up into court and ask for the court to shorten time, to basically bump up the hearing date. If the courts are egregiously doing, like say they're setting it for 21 days or 30 days out, then yes, I would say avail yourself of that right to go in and seek the court to advance the hearing date.
Mhm.
If it's a few days, you're probably at the court's mercy. Like I said, you're probably going to be, this law is probably going to be subject to courtroom availability. Um, I suspect the courts will try, but it will probably be more like a 7 to 10 day period, in which case it's just not worth it to try to advance the hearing date. But if they're setting it way out, then yeah, you can go in and advance the hearing date or ask the
Mhm.
court to advance the hearing date. And depending on where you are, courts are oftentimes accommodating.
Yeah, good question. I didn't know that myself, and I guess a few days is kind of annoying, but it is what it is. Longer than that, it's actually an issue that you can definitely get some time made up for, hopefully. Vicky asking about the new law about the online payment of rent or check and the fees involved with that, as well as the tenant screening fees. Do all of these laws also apply to commercial, or would you say that commercial is just totally different and not included in this?
Good question. Commercials, there were some commercial changes.
Hmm.
I didn't bring those up today, but these particular ones do not apply to
Hmm.
commercial.
Okay. All right. We'll do a separate thing for commercial perhaps at some point, Steve, if there are some significant changes there to just talk about. Carla asking, Also about the screening fees, if I do not charge a fee for screening tenants myself, but instead I use a credit screening company, or let's say apartments.com, Zillow, and they're running it and they're charging a $35 fee or whatever it is that, if that's a third party, does that count?
Yep, that's still a fee. You're still subject to
Mhm.
this. Yep.
Yep. Okay. Also, few people had the same question there. Also, what if you don't charge a screening fee, but you ask the tenant to buy their own,
To buy their, I'm sorry?
to buy their own report? So they're you're not requesting it, but you're asking them to go to like TransUnion, SmartMove, and buy their own credit report from them.
Oh, okay. So yeah, so you're not charging any fee. So if that's your standard I wouldn't necessarily recommend that. I would recommend you
Yeah.
a report. Now, I do see tenants who come, they come with their report. So here's my report. If you want to rely on that, that's fine. That's not a screening fee, but I'd probably suggest you do your own due diligence and pull the report.
Yeah, I agree. It's so easy. And it's so funny too, because we get a lot of calls because, AAOA, we sell screening reports to our members. And sometimes a tenant will call and say, hey, how come my score is so different? Or how come my report looks different? And the truth of the matter is, or a landlord might ask that as well, maybe it looks so different than what the tenant gave them. It could be that the tenant is making changes on the reports. It's not hard to do that. Or it could be that their report changes. I mean, even month to month, it can make a difference if so, a new line of credit was added or a new late payment that wasn't on the previous months. So it's always good to have, I think, the most up-to-date report if you're going to make that decision and that you have it from the source so you know that the tenant didn't make any changes to it.
Yeah, I agree.
All right, Svetlana here. If I have only one application and it doesn't match my criteria, but I haven't received any others, can I deny the applicant? So I think it's yes at
Yeah,
that
yeah.
point.
So
Yeah.
long as your criteria is
Mhm.
non-discriminatory, then yes.
Great. See another one here, similar question. When should I return the tenant screening fees if I own only a single family rental? So I suppose if it applies, I guess, to just if you just had one single family.
Oh, it does. It does apply that
Mhm.
as well.
Okay. And I kind of see that trending here. It seems like most of these laws now that have been passed are applying to the majority of, landlords, whereas maybe before it was just the larger operators. It seems like they're starting to target really all rental owners in a lot of these cases. May says, if I send the link to the tenant, they pay to complete that application. I don't end up renting to them. Should I return the tenant's fee or the tenant screening fee?
Yeah.
And yeah, so basically, yes, or consider them in the order received.
Yeah, yeah. So if you decide, if you elect to, um, to comply with these laws, then yeah, you just have to consider them in the order received
Mhm.
and take the first available.
Mhm.
The first, not first available, but the first one that satisfies your requirements.
Okay. Alan asking via the application fee, can I legally ask a prospective tenant to answer a free pre-screening questionnaire before I send them the application?
Yeah, well, I suppose, yeah, I don't see any problem with that, but I suppose it would depend on what that questionnaire says. Again, I'm seeing I'm seeing a lot of these like nonprofit organizations who are suing landlords or filing fair housing claims for violations of listings and screenings, um, as discriminatory. So you need to be really careful. I mean, it depends on what those questions are. I don't see any problem with having a conversation with someone and gauging their interest, finding out about them. Um, but if you're using that to determine whether or not you want to consider them, it better be for legitimate reasons.
Yes, definitely legitimate reasons. That's the key. Also, I will be sending everyone the slides and the recording tomorrow for those of you asking. Jean asking, what about protection for landlords against a tenant who lies, obstructs maintenance, or uses the legal system to sue? Uh, I'm assuming for not a legitimate reason.
Yeah. So, well, the landlord's recourse is if the tenant is violating any provision of their agreement or violating the law, you can always avail yourself of a just cause to displace the tenant. Um, if and it's not a, I don't put it past tenants when they are asserting claims against landlords to embellish or even fabricate claims. Um, in that scenario, unfortunately, you've just got to go through the process of defending yourself, and hopefully proving that in a court of law. But generally, you are subject to the provisions of the rental agreement. So for breach of contract, you can avail yourself of any rights you may have, which may include eviction or suing the tenant for some lawful breach of the lease. Um, but yeah, you're right. All these laws, a lot of them are favorable to tenants, like I was saying. You don't get laws that are passed favorable to landlords. You just don't these days. Everything is for the tenant. So landlords are on their heels. It just is a cost of doing business, unfortunately.
Hmm. Yeah, lots of comments in the chat about California going insane. I heard from John, and it is what it is. There are some good pros and cons to being a rental owner in California for sure. Angela asking, what incurable lease violations can be used to evict, and how many violations are required?
Okay, this is going to depend on where you are,
Hmm.
which jurisdiction. I'll answer just in a general sense of under TPA, for instance. Um, Most breaches are going to be curable. I suppose, anything that would be non-curable would probably amount to a nuisance. Okay. For a nuisance, you can generally evict with um, a 3-day notice. Now, depending on the nuisance, if it's something that can be abated, well, here you said it's non-curable. So I would think maybe like burning a house down, or I don't know, um, something like that, that's evictable generally with a 3-day notice. Um, but most lease violations are going to be curable. And in that scenario, you have to give 3-day, well, under TPA, under the Tenant Protection Act, you have to give a warning notice first. And then second, a notice to perform or quit before you can evict. So there are some opportunities for the tenant to try to come into compliance. If
Hmm.
it's something that's a nuisance, then you may not have to give a opportunity to cure. You might be able to just evict without that opportunity. Again, it depends on the nuisance. It really does.
Hmm. Yeah, Jay was also asking what's the difference between that 3-day notice and the 10-day notice, if you could clarify that a little more.
So yeah, that was San Francisco specific. The 10-day notice was a pre-warn, it was a warning notice, but a pre-3-day notice. So the example I'll give is non-payment of rent. You have your 3-day notice to pay rent or quit. The law required the landlord to first give a 10-day warning notice. Hey, you haven't paid. You better pay, or else. Well, when that time runs, then you can give your 3-day notice. So it was an additional notice.
Mm.
Sometimes jurisdictions impose an additional type of a warning notice like that. So it's an additional, not in lieu of.
I see. Okay. Some more questions about moving in and remodeling. Alan asking, after moving in, does the owner need to file any document to any legal authority?
So if the tenant moves in, does the landlord have to file any documents? So this will be jurisdiction specific again. Um, some jurisdictions have rent registries where you have to register the unit with the local rent registry. Um, I'm not aware of actually filing any particular documents. It's usually informational. You provide information about the rent. and the tenancy. This allows the local jurisdiction to track the tenancies. Um, so I am aware that's in Berkeley, Oakland, and San Francisco. I believe Alameda City has one as well. So if you're in a jurisdiction, you may have to register the unit and report certain information. But I'm not aware of a filing of anything like tenant documents or anything like that. But that's probably coming at some point.
Yeah, it wouldn't surprise me. Um, Carla asking if I move a tenant out due to a significant remodel to the unit, do they have the right to move back and pay the same amount as before, or can you charge more? Linda had the same question as well.
Yeah, they're generally going to be able to move back in under the same terms as they moved out. Now you have your rent increase rights under Tenant Protection Act, which is what, 5% plus CPA, not to exceed 10%. You might be able to avail yourself of that. But in general, yeah, they'll be able to move back in under the terms of their tenancy.
Mhm. And Janice asking, can landlords add the owner move-in exemption addenda in a renewal lease if it didn't appear was not provided in the initial lease?
So this may be, I don't know if this is a local, a specific question, because when that question comes up, I think Oakland specifically, because
Mm.
Oakland has a provision that says you can displace the tenant for owner occupancy purposes um, if there's a provision in the lease that allows for it.
Mm.
This is different than the broad overview of an owner move-in eviction right. This is something very specific to Oakland. So to answer that question, if you do a new lease, um, I would argue yes, you could avail yourself of that right. I think a tenants advocate would probably disagree with me, so we probably have to fight it in court. They'd want to say it has to be in the initial lease, which there may be some argument to that. Now, other jurisdictions may have some similar provisions, but I'm aware of specifically only Oakland that has that particular unique provision.
Right. Does a vacancy tax apply to HUD units?
So this is, again, the vacancy tax is very specific. It's not in San Francisco anymore. It's not being enforced in San Francisco right now. It is I believe it's kicking in Oakland and Berkeley. So generally a HUD unit. Now that's to be distinguished difference between renting to a HUD tenant, like a Section 8 tenant, but HUD units are generally controlled by HUD. So that very well may be an exception to the vacancy tax in those local jurisdictions. But you'd have to double check there. But those particular buildings are HUD buildings and generally regulated by HUD. So so long as HUD doesn't charge you for that, you're probably okay. It's probably an exception. But again, check the local jurisdiction.
Hmm. Okay. Seems to be the theme here. Charles asking, are landlords now required to pay interest on security deposits?
I hate to keep echoing this, but it depends on where you are.
Mhm.
Overall, no, not yet. But if you're in San Francisco, yes, you do have to pay interest. So there may be other very specific jurisdictions where you do, but in general, under Tenant Protection Act, in general, under state California law, no, you don't have to pay interest. But it's coming. It'll be a matter of time, I'm sure.
Hmm. Yeah, unfortunately. Kevin says, on a duplex that is under the Tenant Protection Act, can I still vacate both units in order to quote unquote go out of business on that rental and then sell the duplex?
In short, without getting into a lot of details, yes,
Hi.
going out of the business. Yeah.
Yes. Um, Rent was raised for someone I know without the rent cap and just cause addendum. What is the recourse for the tenant?
Yeah, so it could be because so just as some background here, I'm assuming this is a an addendum or the disclosure for an exemption under the Tenant Protection Act. So to avail yourself of the single family home exemption under the Tenant Protection Act, you have to include lease language in your lease that says it's exempt as a single family home, and include it with any change in terms of tenancy. Okay. Um, so if you are changing the terms of tenancy, then you need to include it with that change in, I'm sorry, lease renewal, any renewals, not necessarily change in terms, but a lease renewal. You have to include it with a lease renewal specifically. A change in terms of tenancy, in my opinion, arguably is not a lease renewal. So if you excluded it for, that being said, I include that language I advise clients to include it with their rent increases, okay? Change in terms of tenancy. I'm of the opinion that so long as you included it in your lease and any lease renewals that you had, then if you excluded it in your rent increase, you're probably okay.
Okay.
But if it hasn't been documented in the lease or in lease renewals, then it
Hmm.
may invalidate that rent increase or your exception to the Tenant Protection Act.
Yeah, yeah. Leonard was asking, saying his home insurance was raised 255%. That's
Wow,
crazy. And
that's
he's
that's
like,
happening. That's happening.
yeah, how can I raise the rent? I mean, you're really just limited to the laws of, how much you can raise. Unfortunately, there's not a whole lot you can do there.
Yeah, there are some,
Which,
like if you're in a local jurisdiction, there are some pass-through rights where if your costs are increased, you might be able to pass those through to the tenant. So
mm,
check whichever city you're in. You might be able to pass through increased costs.
okay. Uh, Still some confusion on whether a landlord can or should pay for that credit report or background check, and whether or not, if they're doing it, let's say Swathi here is saying if they're applying through Zillow, they pay the $35 application fee. Both the landlord and the tenant get a copy. Do they need to credit them that $35 application fee?
I
Or
would say
what, or
that's
when?
charging them a fee, subjecting you to the requirements
Hmm.
of this new
Hmm.
law. Um, so one, either don't do it, or two, yeah, you refund it.
Yeah, yeah. And just to let y'all know, if you go to AOA.com and you are using screening, or for those of you joining from Tenant Alert, our sister company, we do offer the ability for landlords to pay for the reports. I know a lot of screening companies only let the tenant pay for it, which gets a little messy because then you would have to, send them a check or something, I guess. On our end, if you do want to pay for it, that option is available every time you do order. So you can just mark that, put in your credit card. That way, maybe you're just peace of mind there. It's just easier. I know it's still more expensive, but certainly could help with that. Okay, yes, recording notes, Q&A, chat. All of it's going to be sent to everyone tomorrow. Steve's information will be sent. Greg's information, if you're here for the first part, will also be sent. All right. Steve, I know we've been on for quite a while. We are almost done with questions, but we seem to keep getting just more and more. How do you feel about taking a few more questions, or do you want to maybe just answer these offline?
I'm happy to stick around for a few more minutes
Okay,
if you like.
sure, sure. All right, let's do it. Does Costa-Hawkins apply in Oakland? I'm trying to evict a tenant from my single-family home. The attorney told me that the city has now amended and now all single-family rentals are under this strict rent control. Can you please comment on this?
So yeah, Costa-Hawkins cannot be preempted by local law.
Mhm.
So it does, if your single family home is exempt under Costa-Hawkins, then Oakland cannot regulate it. Rent for rents, it can for evictions. It is still subject to eviction control.
Gotcha. Okay. Beth asking here, still trying to understand who is exempt from offering credit reporting for tenants. So I think this is the rent reporting, not credit reporting. So that rent reporting law that came out, if a landlord owns several separate rental buildings individually, but don't have 15 units in each building, and the sum of all the units is less than 15 units. So all owned by an individual,
Yeah.
would they be exempt?
So they all have less than 15, right? Yeah.
Yeah.
Then
So
it would be
yeah,
exempt. It would be exempt.
okay, great. Let's see here. So going back to Zillow, if the applicant shares the application with you, so they both get a copy, does the law still apply requiring you to accept them in the order received?
Oh, again, only if you're charging a fee. Only if there's a
Yeah.
fee being charged.
Yeah. So you can either charge the fee and do it in the order received, or you can not charge a fee and then you still have the option to sort of look at all the applications and make a decision, but then you would not charge anyone for it. Or I assume, yeah, you would return it if you needed to.
Yeah, so it's an or. So it's
Yeah, yeah.
yeah, you either comply with the order or you just return the entire fee within 7 days.
Mhm. Okay. Michelle here, I have room rentals in a single family home. Do I have to provide locks on each of those doors?
So yeah, okay, so this goes back to the domestic violence question.
I think so. Yeah.
Okay.
So, yeah.
Yeah. So, okay. So, well, let's say domestic. So, let's say the victim is in room one. I would argue that it would be limited to that room, unless um, the tenant also requests that the entire unit be locked. Okay. So, let's say the abuser has a key to the main the house or the unit, and not just the room, then I would say you'd probably have to change both locks, the room and
Mm,
the master, the front door. But no, I don't
yeah.
think you have to change it for rooms of people who are not the victims, just the room of the victim and possibly the main entry.
Yes. Okay. Again, smart locks would make that so easy. Donald asking, can one charge for cleaning an apartment after move out to bring it to the same level of cleanliness at inception of the lease?
Generally, yes. Yes.
Great. Okay. How often should a landlord update their lease agreements versus sending out an extension of the existing lease?
This one will vary again, because some jurisdictions you just can't update it. They won't, the laws prohibit it or make it very difficult to do so. Um, but so a couple things. So yeah, I would always encourage that at a minimum, if you're going to do a renewal, that you do just a simple renewal document, include any disclosure that is required under the Tenant Protection Act with that renewal, as well as any disclosures that may be required locally with any renewal that you give. That's generally sufficient. If there's been any significant changes to the leases are pretty, there's minor things here and there from year to year. So, if your organization where you get your lease updates their lease, yeah, you could go ahead and do it. It's not necessary unless there's significant changes. Just remember, always include whatever disclosures are required at the state level and or local level. That's very important for any renewal.
Mhm. Okay. Nancy asking, where do you find local rent control laws or local laws? What would you say is a good place for them to go?
Yeah, so all of them have a website. So
Mhm.
wherever you are, whether it's LA County, they're going to have, or the city, they're going to have its own website. That's good for some basic information, and you can even call. They'll usually provide you with some basic information, so you can just familiarize yourself. If you're looking to get in the nuances, or if you're looking to actually take action against the tenant for something, you should probably consult with a lawyer in that jurisdiction.
Honestly, yeah, that's the safest bet. Sukdev asking, how can I figure out if my single family residential property is exempt from Costa Hawkins?
Um, so that's a good question. So in general, most single family homes are exempt. The main exceptions, and there's actually several, but the main are if you rent it to the tenant that's in there prior to 1996. Okay, so if they were there December 31st, 1995, a very long-term tenant, you're going to be subject to the local rent control. That's the main one. Or if you evicted a tenant with a 60-day notice, or you raised the rent on a tenant and the tenant moved out because of that rent increase notice or because of that eviction notice, and then you turn around and rent to someone new, that new tenant will be subject to the rent that the prior tenant was paying and subject to local control. It's just a little nuance here in the law. The other main one is that if the unit is subject to a notice of violation for health and safety issues, and that is outstanding, you may be subject to local control. So get that corrected. Those are the main ones. There's some other ones as well, like if you're renting rooms. Someone mentioned earlier that they rent rooms in a unit. If that's a single family home and you're renting rooms, it's not going to get the protections of Costa-Hawkins because you've created multiple tenancies within a room, within a unit. Those are some of the main exceptions to Costa-Hawkins, but if you're not subject, if those don't apply to you, then there's probably a pretty good chance it's exempt under Costa-Hawkins.
Good explanation there. And of course, check in if you're not sure with an attorney. David, if the first, oh, did I lose you, Steve? I may have lost Steve. Are you still there?
I'm still here.
Oh,
I don't know what happened to the
you're off
video.
camera. Okay. If the first tenant is approved on financial, so this is for tenant screening. So if their financial checks out, but they are previously incarcerated, past eviction, do you have to take that tenant?
So there are now some protections for, and this was something that went into effect in 2024. I maybe could have brought it up here, but there were some, again, it may depend also on where you are. There are some very strict requirements for some discrimination laws for denying an applicant based on past criminal record in certain jurisdictions. And now at the state level too, whereas if you do, you have to follow certain steps and even give the tenant an opportunity to explain how that, that criminal history, doesn't affect them. So in general, you may have to even consider someone who has been previously convicted of a crime. So the short of it is you may have to consider and maybe even accept that person. But if you reject them, then yeah, I would return their fee that they paid if you aren't going to accept them. Absolutely.
Okay. Nancy asking, what are the days ahead of a rental raise that you have to give notice if they've lived there for over a year?
30 days if less than 10% or 10% or less, 90 days if greater than 10%.
Okay. Margaret asking, I'm still concerned about the domestic abuse law. If the abuser is on the lease, is it legal to completely lock them out? What can the landlord do, or what are they obligated to do for them?
So yeah, that you want to be careful about locking the abuser out if the abuser is a tenant. So the tenant has rights. So like I said, in that scenario, the victim, you may be subject to allowing the victim out of the lease or the victim to move. Now, oftentimes the victim will obtain in that scenario, a temporary restraining order. And that temporary restraining order may allow the victim to keep the abuser out of the unit for a period of time. In that scenario, you could then change the locks, right? And if there's a court order requesting or authorizing the stay away, then you could, like I said, take steps to help change the locks in that scenario. But in terms of actually evicting that abuser, that's a tricky situation. You can't necessarily evict a person from a unit unless you have just cause. So if there is some cause, then you may be able to do so. But absent that, you want to be very careful. Um, and be very careful about locking that abuser out without something more like a court order.
Mhm. Okay. Um, uh, that's a tricky one for sure. Thank you for clarifying that again. Joe asking, he has a single family home in Oakland. Can he end the lease at the end of the 1 year lease agreement?
Well, by ending the lease, it would just automatically go to month. If by you mean terminate the tenancy, no, you can't, not unless you have just cause.
Okay. Um, Okay, so I think I just answered a duplicate question here. I dismissed a few questions that were also duplicate. If you did miss Steve answering those questions, I will be sending the recording to you all so you can go back and review this entire thing. We will also be providing the slides, the recording, the other slides from the beginning, Steve's contact information, Dr. Balcony's contact information. I'm going to close it out here. If you put any questions in the chat, we did not go through the chat for questions. There was a lot going on there. So if your question was in the chat, you didn't put it in the Q&A, please send over the question to us directly so that we can address it if you do want that question answered. Steve, thank you
Oh,
so much for staying this long. I mean, what an amazing amount of questions that everyone had, and a great job that you did really answering all of these different laws. There's so much to really keep up with and to be in the know with, and it's difficult. It's challenging to be a landlord in California, and I thank you so much for helping make it a little easier and a little more clear, really, for all of our members.
yeah, I'm glad I could come on and do it. Yeah, so I hope y'all got something out of it. Thank you so much for having me. I really enjoyed it, and I'm always happy to help out when I can.
Wonderful. All right, everyone, please take the exit survey as you leave. Love to hear what member benefits you want to see us add in the future, as well as what you thought about this webinar. Really happy to have you all stick around for so long. I hope you have a wonderful week ahead, and we'll see you on the next webinar. Take care. Bye.
Bye. Bye.